They have been forewarned, and they know it's pink, and they know it's Unit 4, and they know that we're not handshaking.
Very well.
And they're ready for it.
Thank you very much, everyone. Please be seated. Good afternoon. My name is Anna Brown. I am a United States District Judge and have the distinct privilege of working in this building Monday through Friday. I'm delighted to be here today and very appreciative of all the work all of you have done to put together today's contestants. To my right is...
Hello, I'm Donald Tousley. I teach government and politics at St. Mary's Academy.
And?
I'm Steve Bass, President of Oregon Public Broadcasting.
And we're all very anxious to meet you. Would you introduce yourselves, please?
I'm Matthew Rowell.
I'm Patrick Benjamin.
I'm William Reed Dustin.
And I'm Kinsey Wilson. We're Unit 4 Pink. We're coached by Kate McKeon, Martha Taylor, Carver Oblander, and Carcella Fale, and our teacher is Miss Portia Hall. Thank you.
Thank you. Are you ready to begin? All right, let's get at it. Unit 4, question 3. The United States Supreme Court has been called a Constitution-guarding court as well as a court of last resort. Do you agree or disagree with this assessment of the role of the Supreme Court? What checks exist on the power of the Supreme Court? What examples of how those checks have been used can you provide? Should there be term limits on the Supreme Court justices? And why or why not? You may begin.
I agree that the Supreme Court can be described as a Constitution-guarding court, but this is an oversimplification because all courts are Constitution-guarding courts and all elected officials take an oath to do the same. I also agree that the Supreme Court can be described as a court of last resort because, as James Madison observed, our political system makes the court chronologically last, meaning that the laws must first be enacted and enforced by 2 other branches before the court can decide a case. Additionally, for ordinary federal litigation, the Supreme Court is the highest appellate court, as set out in Article 3, Section 1. The phrases Constitution guarding and last resort do not necessarily mean this is a constitutional court of last resort. Although the court itself has claimed this role, for example in Cooper v. Aaron, 1958, which established judicial supremacy over the states, and City of Borns v. Flores, 1997, which established judicial supremacy over Congress, the other branches and the states have sometimes resisted this idea of judicial supremacy.
For example, President Jackson defied the court's decision in Worcester v. Georgia, 1832, and McCulloch v. Maryland. President Lincoln disobeyed Justice Taney's writ of habeas corpus in re Merriman, 1861. President Franklin Roosevelt tried to thwart a court hostile to New Deal legislation with his court packing plan. Presidents since Ronald Reagan have used signing statements to give themselves the final word on unconstitutionality. Congress resists judicial supremacy by passing legislation overturning Supreme Court decisions, as seen in the 1991 Civil Rights Act, which overruled parts of Ward's Cove Packing Company v. Antonio in 1989. Congress can also ignore Supreme Court decisions, as it has done in continuing to enact legislative vetoes, despite the Supreme Court's ruling them unconstitutional in INS v. Chadha, 1983. Third, Congress can, with the states, amend the Constitution, such as overturning Dred Scott v. Stanford, 1857, with the 13th and 14th Amendments.
Finally, the court itself can undermine the finality of its own decisions by overruling them, as it did in Lawrence v. Texas, 2003, stating an anti-sodomy law was unconstitutional, despite earlier holding such a law constitutional in Bowers v. Harvard, 1986. The President checks the Supreme Court by nominating federal judges with the approval of the Senate. Congress checks the Supreme Court by setting the number of its judges and through impeachment, although this has only occurred once. The court is checked by the case or controversy requirement of Article 3, Section 1, as well as by the necessity of a majority for a ruling. I agree with life tenure for Supreme Court judges as provided by Article 3, Section 1. First, wise judges should be allowed to remain on the court as they become more experienced. Second, life tenure for judges insulates them from political pressure in the form of election campaigns or threats to remove them for their decisions. In this way, life tenure enhances the Supreme Court as the protector of political minorities from the oppression of majorities.
I disagree with my colleague. When the Constitution was first written, lifespans were shorter and the average tenure of a Supreme Court justice was about 15 years. Now, it is not unusual for a Supreme Court justice to serve for over 30 years. Justices Stevens and Rehnquist both served for 34 years, and Justice Douglas remained on the bench for 34 years despite a debilitating stroke. It is no longer true that life terms make justices nonpartisan. Nominations are dictated by political agendas, and justices do not shy away from partisan politics. For example, Justice Thomas's wife served as CEO of Liberty Central, a Tea Party-affiliated organization. Justice Scalia attended a retreat sponsored by the Koch brothers while the court was deliberating the case of Citizens United Federal Election Commission in 2012. Thank you. We're now ready for your questions.
Let's see here.
I think I speak loud enough. Alexander Hamilton in Federalist Paper 78 said that the judiciary will always be the least dangerous to the political rights of the Constitution, having neither sword nor purse. Do you think he was right, and how did that play out over time?
I believe that the court is restricted by the absence of any military power or financial power that Congress has. However, I believe that that's appropriate, as the court is the farthest from the people, as they are not directly elected, and therefore the limitations that have put on them and that has been put on them and that have continued to affect how they impact the country are appropriate.
Thank you. Mr. Haslett?
To what degree can the Supreme Court truly be a Constitution guarding court if the loose and strict constructionist members of the court disagree about what exactly it means to guard the Constitution?
Well, I believe that the Constitution is not a rigid document, and James Madison said that it is not a suicide pact, and that the Constitution needs to be open to interpretation and to change, as we saw with the 13th and 14th Amendments, ending, abolishing slavery and giving all people in the United States the right to vote.
And the differences in opinion between strict and loose construction can add to debate over new evolving ideas over intellectual privacy in the electronic age.
As well, the different interpretations reflect the different beliefs and interpretations of how the Constitution should be interpreted across the country, and therefore the different justices interpreting the Constitution differently reflect the times as well as the opinion of the people.
Thank you. So, can you explain what a writ of certiorari is, and under what circumstances should or would the Supreme Court grant one?
A writ of certiorari is when the Supreme Court says they will take a case, and the Supreme Court does not take more cases than it takes in, and a writ of cert allows for the Supreme Court to take cases that they think at that time are most important. As currently, we learned yesterday, the Supreme Court is going to rule on gay marriage, and also on March 7th, they're going to be looking into the Affordable Care Act in a case called King v. Burwell, where they're looking at the final precedent of the Affordable Care Act and looking at how federal appropriations are to be set out to states.
Why do you suppose, though, that it was only this week that the Supreme Court exercised and granted a writ in the same-sex marriage cases when there have been many petitions to the court to consider the issue in the past? What are the conditions under which it was granted this time that didn't exist before?
Because it was such a controversial case, the Supreme Court wanted to, or because it was such a controversial issue, the Supreme Court wanted to wait and see if the country just naturally shifted one way or another. And as we saw with the continued legalization of gay marriage in more and more states, it's becoming apparent that the country is leaning more towards support of gay marriage. And I think the Supreme Court was waiting for that kind of appearance in the country before they ruled on it.
Additionally, there is now a conflict between different circuit courts on the issue of gay marriage and whether or not a state can ban it.
Thank you.
Why does the Supreme Court refuse to issue advisory opinions?
This was deemed too much power for the Supreme Court. The case or controversy requirement for the Supreme Court to rule on an opinion is one of the most important foundations of our judicial system. And so if they were able to issue an advisory opinion, that is skipping the entire process of requiring a personal injury for the case to come to a lower court and then be appealed to the Supreme Court.
In addition, this fire alarm system allows the court to save time on cases that may not cause theoretical problems in the future.
Thank you. Briefly, how would you distinguish between original and appellate jurisdiction within the Supreme Court?
Original jurisdiction is when a case has not been seen by a court previous to the Supreme Court. And this occurred, for example, after the 2004 election, I believe, between George Bush and when the votes in Florida were in dispute. And appellate jurisdiction is after a case has progressed through the other courts, from the district courts to the appellate courts up to the Supreme Court.
The case my colleague is talking about is Bush v. Gore, where the Supreme Court had to decide whether or not the vote should be recounted within those states, within Florida specifically.
Was that an original jurisdictional question or one of appellate jurisdiction?
It was one of original.
Our time's pretty much up. We'll call it good. Good job.